Going to start now. Today is 189th Friday group meeting. The topic is jurisdiction of tribunals in India. The speaker is our beloved advocate Ms. Kumudlata Dasji, advocate on record also. Earlier also she addressed our Friday group meeting on 8th February 2019. The topic was mental illness and right to marry. Kumudji, you know, aware of our Friday group and all.
Yes.
So thank you very much for coming, and you have chosen a very good topic. Since long she is requesting me, but somehow we managed to get a date. Please. क्लिप लगा साइड पे लगा
ठीक है वो कैच करेगा।
हाँ आ जाएगा। ओह परफेक्ट। बोट होने से ये प्रॉब्लम है। नाउ यू कैन।
Yes. Good afternoon, everybody, and thank you, Seshu. He is an old friend. He is doing wonderful job with the Friday group because this is a part of the continuing legal education. And lawyering is an ever-learning process. No lawyer can say he knows everything. So we are all learning, and that is how this topic which I have chosen, jurisdiction of tribunals in India, becomes relevant after the 2023 judgment of Justice Pardiwala sitting with Justice Manoj Mishra. This is a judgment where the jurisdiction of the tribunal, that is NCDRC, has been talked about. It has not been enlarged actually, but it has been interpreted. And Tribunals Reforms Bill 2021 has in fact included tribunal in the Act Consumer Protection. With this I start. So I will take you through what was the position of tribunal pre-1976. When I say that, what I mean is 1950 to 1976. In Article 136 and Article 227, you had the word tribunal. Article 136, we all know, we are Supreme Court lawyers, that it's non-obstante. Any order, any determination, any judgment, anything can be challenged by way of a special leave to appeal. And the order has to be from any court or tribunal or any other authority. Tribunal was used there in Article 136. 227 is a supervisory power, or we can call it a power of judicial superintendence over the inferior courts. So 227 also had the word court and tribunal. So as far as court and tribunal were concerned, 226 and 227 and 136 were one and the same. What happened in 1976? And why do I say pre-1976? 1976 42nd Amendment took place. That amendment is an amendment of exclusion, and tribunal was ousted from there. So once we said that now courts cannot look into the orders passed by the tribunal, Part 14A of the Constitution was introduced. Part 14A is Article 323A and Article 323B. Article 323A is the genesis of the administrative tribunals. The background, legal background at that time was that service matters were by and large a lot in number, and high courts were flooded with those cases. So the idea was that let the high courts be burden free of the service matter, and they should be tried by a special court, that is a special tribunal. And tribunal is a creation of a statute. That is the basic difference between a court and a tribunal. Tribunal has all the trapping of a court, but it is not a court. So when we say this, what do we mean? We mean that tribunal will not have the tardy procedure of a trial. It will not get into the evidence. And tribunal can make its statute, makes its own rules. So tribunals are guided by those rules, and they can also make their regulations. So coming to the Administrative Tribunal Act, this is what was the position, that is 323A. 323B is our other tribunals. Other tribunals meant it could be industrial tribunal, DRT, everything came later on by way of a statute. But that is how 323B was, tribunals other than the administrative tribunal. Subsequently, in between, in 1977, there was a bill introduced that was in Special Courts Bill 1977. That was a reference under Article 143 before the Supreme Court. And Article 143 has got two parts. Part 1 is not mandatory, Part 1 is directory, Part 2 is mandatory. So Article 143(1) is directory. It sought an opinion, the President then sought an opinion of the Supreme Court to find out whether the Special Courts Bill is all right in law and does it serve the purpose. Special Courts Bill introduced a special class of offender who would be triable or who would be tried by special courts. So you have the famous Antule case also underneath that. Now coming to 1978, I am going year-wise, like in Supreme Court we go with the sequence of event. 78 was 44th Amendment of the Constitution. 44th Amendment undid, or you have the undo button. So it undid with quite a lot of provision which were introduced by 42nd Amendment. If we get into the plethora of those amendments, we'll spend weeks together in explaining that. But as far as the word tribunal was concerned, so it restored the word tribunal into Article 227. 136 was not touched, neither in the 42nd Amendment nor in the 44th Amendment. 44th Amendment also made certain changes as far as the parliamentary power was concerned. And it said that no, it should be people friendly. So it should not be parliament, should not be supreme. And it introduced the judicial review in its true concept, saying that a legislative action can be challenged by way of a judicial review, which was also Keshwanand Bharti case. So these are three phases. Now what are the judicial determinations and how the courts have gone through to Article 227, Service Matters, Administrative Tribunal Act. We have a 7-judge judgment of L. Chandra Kumar. I think everyone must be aware of L. Chandra Kumar. L. Chandra Kumar in the line of cases is one case which again dealt with the basic structure doctrine. L. Chandra Kumar has a background of Sampath Kumar case. Sampath Kumar challenged the constitutional validity of Section 28 of the Administrative Tribunals Act. Section 28 again ousted the jurisdiction of the courts. So why are the courts so touchy, is my question to myself and to all of you. That the moment we say that courts will not look into this matter, then what suddenly happens? This is what was decided in L. Chandra Kumar. L. Chandra Kumar said no, you will not straight away, rather L. Chandra Kumar reduced the tribunal, that is the administrative tribunal, to that of the court of first instance. It doesn't say district court, but it says this is the court of first instance. But accordingly, it is a judgment which also says that 80 under the Administrative Tribunal Act, you can examine the virus of a provision. To examine the virus is a constitutional issue. So there are very interesting entries. Now entries are made under the 7th schedule. 7th schedule takes its power from Article 246. If I am too fast, please tell me, I will go slow. Because let me go with the provision. So Article 246 talks about the legislative power. We have a federal structure in India which is unitary in character. When I say this, what I mean is that you have three lists. List 1, which is the union list, list 2, which is the state list, and list 3, which is the concurrent list. Now whenever there is a conflict between any entry in between the list 1 and list 2, and assuming that entry is in list 3, then list 3 will prevail over list 2. And courts were included in list 1, entry 79. That is the union list. Under entry 65 of the 7th schedule, it was entered in the state list. That is the list 2. Administrative decisions were included in list 3, That is entry, I'll have to look into it, but entry 14 was there, and entry 14 of list 3 gave the power to the administrative tribunal to hold someone guilty of its contempt. Contempt power otherwise is not with the district courts. Contempt is a constitutional power, along with the Contempt of Courts Act. But here, the CAT, that is the Central Administrative Tribunal, or the State Administrative Tribunal, they have a power to issue contempt if any of their order is not followed. So the concurrent list, the entries were 11A and 14, as I pointed out. With this backdrop, now coming to visit L. Chandra Kumar, and I say to visit that case because that case has got a paragraph, and I will only refer to 4 paragraphs, read it on your own, I will not read it because that will become too lengthy. That is paragraph 82, paragraph 90, paragraph 91 and paragraph 93. Now paragraph 93, let me just read that one side it says that you can examine the virus of a provision. On the other side it says you are the court of the first instance. So is it not equating the tribunal to that of a high court or to that of the Supreme Court? Because L. Chandra Kumar also says that Article 32 is the soul of the Constitution. So if Article 32 is the soul of the Constitution, Article 226 again is the soul of the Constitution, of course including the legal rights, then what is wrong with and if the tribunal is looking into the virus of any policy, then on the other side the dichotomy is that you are saying no, every order issued or passed by the tribunal will now have to go through the High Court, and only when the High Court looks into the judgment by way of a writ of certiorari, then only it can go to the Supreme Court. So this 3-tier system, in fact I personally say that it is not very healthy for the judicial health of the country, because we have a serious backlog. I am neither supporting 42nd Amendment nor 44th Amendment, but 42nd Amendment had a background and it was to deal with the backlog. And I think as lawyers, every year we come across, once there is a situation once a year, that what about the pendency of the cases. So in Chandra Kumar, interestingly what was thought was that Article 136 is a very costly provision. It talks about the cost. Justice Pardiwala's judgment, Universal Sompo, also talks about the cost. And Omex matter, which is that's the Omex matter 2022, that again talks about the cost. So if courts are so conscious, and if the Honorable Supreme Court is so conscious about the cost aspect, is not Article 226 a costlier litigation than Article 32? This is question number 2. That cost cannot be the criteria of saying that no, you go to the High Court. If the High Court was the final determinant court and saying that the matter will not be appealable now to Supreme Court, it was well understandable and it was quite logical also. That a person who is a service person, assuming he is fighting a case of his pension, or if he is fighting a case of his compulsory retirement, which is a punishment, it is not VRS, and it goes on for 10 years, then it goes to the High Court. So say a full stop should be the High Court. If a full stop is not the High Court and it is just a route to the Supreme Court, then this entire process, if we look into the statistics of the cases after L. Chandra Kumar, that is 1997, I think nothing, pendency has not reduced. It has only increased. And the biggest litigant in the country, interestingly, is the Union of India. So Union of India takes a legislative action, the judiciary looks into the legislative action, gives its own judicial review over the legislative action. That is what is Article 13 and that is what is Article 368. That is what was Keshwanand Bharti case. That if you are amending or if you are bringing about any change or amends in the Constitution or a statute, qua the Constitution, Can it be judicially reviewed? The answer is yes. That answer anybody and everybody will agree, because it does encroach upon at times your very fundamental right. So Keshwanand Bharti was on the right of property, which is no longer the fundamental right, but L. Chandra Kumar was on the right to equitable relief vis-a-vis a person who is a service person, who has served the government either at the state level or the union level, and for ABC reason, it can be his transfer, it can be his promotion, it can be his retirement, it can be his pension, it can be so many things, or it can be against a departmental inquiry. Then initially, if I am correct, till 1990 there was also a provision that when a service person is issued a show cause, there are two steps which are taken. One is a departmental inquiry and the other is a criminal action. In case if he is hauled up for, say, fudging of the accounts, then the matter will go to the criminal court. If the criminal court finds him not guilty, then it was automatic absorption into the service, which is not the situation now. So you have to again go to the CAT, file a OA, original application, get an order. You get an order, your service cannot be reinstated because the government will go to the High Court. If the government loses in the High Court, then government will come to the Supreme Court. So Article 227 and Article 136, government is using more for itself. And on the other side, it is also complaining of the long pendency. So the backlog of the cases and the amendments to the Constitution have to be read one and side by side. So this is what is Article 227, this is what is Article 136, and why did it include the word tribunal was always that something which is other than the court. Let us have a statute which will deal with a special subject matter, and jurisdiction are three. One is pertains to the subject matter, the second is original, the third is appellate, fourth is territorial, then you also have the pecuniary jurisdiction. So service matter, we don't go much into the pecuniary jurisdiction because you have only one forum. But if you go to the consumer court, you have to also find out, you have three-tier system. So what is the pecuniary jurisdiction? The 2022 case, which looked into the Consumer Protection Act, was Ibrat. I'll just tell you, this is Ibrat Faizan versus Omax Build Home Private Limited. The citation is 2022, SEC Online, Supreme Court 620. The issue here was the dispute between a flat buyer and a builder, which is one of the most common issues. In between, this case was filed under the old Consumer Protection Act, but from 2019, you have the new Consumer Protection Act. 2019 has got section 58. 58 has got 4 parts, Roman 1, Roman 2. Roman 1 and Roman 2 say that you can directly come to the Supreme Court by way of an appeal under section 67 if in case you are aggrieved of any order or judgment passed by the National Consumer Dispute Redressal Commission, where we go for a original complaint. Here the issue was 58.1 Roman 3. Now what is 58.1 Roman 3 is that if the case is filed because of the jurisdiction in the State Consumer Dispute Redressal Commission, the State Commission passes an order, you will go into an appeal in the National Commission. The court herein looked into this aspect and said that a substantial right of your relief is taken away because you cannot go in for a second appeal or for a revision. So you must again be en route through the High Court. And there the power of Article 227, which is not only a power, it is an authority because it talks about the superintendents. The fact of the case are very different. The flat buyer got some money and then fact I'm not getting into because I'm just dealing with the law. So 58.1a Roman 3 was held to be the correct proposition of law, and it was held that High Court can look into the issue. What happened when the High Court looked into that issue? The compensation which was not given or not affirmed by the National Commission was granted by the High Court with a 50% deposit made mandatory. So that is how Ibrat is the matter, is the case which propounded the principle of law as far as 58(1)(3) of the Consumer Protection Act 2019 is concerned. After Ibrat, there was another matter which was arising out of a motor accident claim, which is Universal Sompo. Here the insurance company came to the Supreme Court, and Supreme Court, it's a two-judge judgment, relied heavily upon this Ibrat Faizan judgment, that is the Omex Build Home judgment, and it laid down the principle that no, when it is 58(1)(3), then because the word tribunal is there, and tribunal is also found to mention in Article 227, the High Courts have a power of superintendence, and by way of a judicial superintendence, they can look into the judgment. So the claimants or the victims of the motor accident claim were given X amount of money. That was reduced to 50%, and 50%, and when the matter came to the Supreme Court, that 50% amount was deposited with the Supreme Court. What happened in this long journey of the case from the commission, state commission to the national commission to the High Court and then to the Supreme Court was that claimants were not available. This you will find it in the judgment. And Supreme Court said that let registry return the amount. So if we make the judicial journey 2 bit longer, it is justice is not even it is not seemingly done also. So delay is a very vital part, and the genesis of the tribunal being a step to curb the delay in the judicial proceeding was not a very healthy thing. This is my very personal opinion. Again, I say I am not quoting from any judgment, but this is the tribunal should not mean that it is mandatory. Now, interestingly, I'll tell you, L. Chandra Kumar, even after the 7-judge judgment and holding that article section 28 is ultra vires, look into this act. It has neither struck off section 28 nor has it brought about any amendment. So what is the use? If we are writing long judgments, we are filling in so many pages. Coming now to another case, a law which I am very frequently dealing nowadays, is the PMLA judgment of Vijay Madan Lal Chaudhary. This is under the PMLA Act. PMLA Act has got section 42, which says that you will go to the High Court against a judgment, but it doesn't say you shall go to the High Court. So it says you may go to the High Court. Even today, AT Act says you may. It doesn't even say anything. It just says it is appealable to the Supreme Court. So without any amendment, if there is a lawyer who has the grit to argue that no, I am coming under Article 136, you are nowhere outside the contours of the law. You may be outside the contours of L. Chandra Kumar, yes. But any law which is declared by a constitution bench becomes a law under Article 141. Supreme Court is an interpreter of the provision. There is only one amendment which I remember was brought about by a judicial determination, that was in Delhi Rent Control Act. It was Justice Singhvi sitting with Justice B.N. Agarwal when he said that even commercial premises can be evicted on the ground of bona fide requirement. That is an amendment which is brought about in the legislation. Rest any amendment you will look into, I have not found, because at least for 2 days I am reading this. So these are the grey areas. What is now Article 227? Article 227 many a times does not exist alone. It is added to Article 226. From the states, if we get the repetitions, especially from West Bengal, Odisha, Bihar, you will see it is written Article 227 and 226 and 227. In Delhi High Court, we don't write that. We write a writ petition under Article 226. So Article 226 is sufficient in itself, but because 227 is a judicial review. Now what is the difference between Article 227 and a second appeal or a revision? Second appeal is not there in CPC also. At that provision of RSA, you now file a CM if you want to challenge a judgment which is passed by the lower courts. So it is for an advocate or in order to do advocacy, first clarity that an advocate should have his mind is what is the jurisdiction of the matter that I have got. Here, because we are mostly dealing in the appellate side, we don't have this difficulty. We just say civil appellate jurisdiction and we file a SLP. But if assuming that you were the lawyer who was doing the matter before the court of first instance, then you would have to look into it. Coming to another act again, that is Surfacy Act. Surfacy Act, if you look into, many laws must be appearing before the DRT. You have a provision of mandatory deposit, whatever is the percentage. It's like a tax law. Tax law, you cannot go in an appeal if you're not done the mandatory deposit. Assuming today you don't have money and you are neither declared insolvent or you don't want to be declared insolvent, do you have a remedy? From DRT it would be DRAT. DRAT will pass no order because DRAT will say that I am bound by the statute. So where would you go? You would go to Article 226. Article 227 is just ornamental out there because then there is no actual superintendence which you are asking the High Court to look into. Once we have not followed a statute, then we are innovating a petition, and we are innovating a petition on the ground that it is violative of my legal right. 226 is more than the fundamental right. When we come to 32, we are bound within the contours of Part 3 of the Constitution, so it has to be only fundamental right. Look at the journey of Article 21. Article 21 is just 2 lines, the smallest article, because another act we have is Evidence Act, which is again 2-line act. So Article 221 is negatively couched, but it has been broadened by way of judicial determination. Many. Has Article 21 ever been amended? No. What has been amended is Article 15 after Indira Sawhney judgment. So it is not that when a judicial order is passed or a law or a judgment which is law under Article 141 is made, then the statute or the parliament should not look into the amendment of the particular statute. So the separation of power which we talk about and we very dearly hold to ourselves, and we say with pride that judiciary is very independent. It is indeed. And today judiciary is the only body where people come to. But after a lot of exercise, after a lot of ink, after a lot of computer now and reels, what happens ultimately is statute remain the same. So somewhere we have to really look into this, that while we are determining either we are including the jurisdiction of a tribunal or we are excluding it or we are expanding it, or whichever shape we want the tribunals to be in, are they serving the purpose for which they were originally introduced in the Constitution? Let us forget about 42nd Amendment or 44th Amendment. Why did the Constitution framers not rest only with the word court? Because they knew even at that time that courts are not enough to decide the disputes which are in this country, which is a populous country and which is the most populous country now. Earlier it was number 2, now it is the most populous country. So looking into the litigant and the judicial mechanism, the ratio being too large, so it said that no, let us have a mechanism of a statute by which we will create a tribunal. The tribunal will look into the subject. So you will find in many of the statutes ousting the jurisdiction, that is even in Delhi Land Control Act. So it is an appeal, it is a second appeal. Somewhere in CPC, what is older than CPC is the concept of res judicata. Res judicata was there even when CPC was not there. That if two people fought on the same subject matter twice, then the determination which is prior in time will prevail upon the dispute which is later in time. So the provision or the doctrine of res judicata is totally frustrated if we have too many forums. Sampath Kumar went a step ahead, and Sampath Kumar said that why only tribunals? Why don't you have alternate dispute redressal mechanism? What is alternate dispute redressal mechanism? You and I make an agreement. You do not fulfill it. We can appoint an arbitrator. Arbitrator is a tribunal. And there is a statute guiding arbitration. He is not doing it uncodified. So if such an informal body can become a court, then finally an award is made. That award is challenged again. That award, depending on the pecuniary jurisdiction, is challenged either before the district court or before the high court. Once the objections are not taken up or the objections are not dealt with, then the aggrieved party goes in for an appeal. After that appeal, again the matter comes to the Supreme Court. So the whole idea of an alternative dispute redressal mechanism comes to a mere dead letter in the books of statute, because 1948 was even more complicated. It was quite complicated, because for making a rule of the award, you could make a rule of the award, then you had to come to the court. No, you had to go to the court to make it a rule of the award a rule. 1996 said no. If an award is passed, let just the court fees be added and be deposited. It becomes a rule. But you have an appeal, and there have been many amendments in 2015 in the Arbitration Act, that is 1996. Third is that tribunals, when I say that it was there and it did away with a lot of procedural rigmarole, like summoning the witnesses, going in for evidences, having exhibits, examining, cross-examining, and like that it was an endless procedure where it had to be done by a person who was legally trained. Arbitration can be done by any person. Labor court, when it said that no, we don't need lawyers, you can come. Family Court Act said that no, we don't need advocates. So finally the result is that when the legislator looks into the alternative aspect, somewhere it has got a concept that advocates are the one who are plunging into it. It is not advocates and the act. It is the litigants and the act. And that is where advocates also protest. They come out with industrial tribunal. There was a strike recently also. Family court, there was a strike. Therefore, what was there was that now family court is again by a special statute. Family Courts Act. I think it's 1984 or maybe 1991. 1984. But family court deals with Hindu Marriage Act, Hindu Succession Act, issues related to matrimonial. Why is it not called a tribunal? Why is that a court? And why is debt recovery a tribunal? Why is labor a court and why is PMLA a tribunal? What is the difference? If you will read into Consumer Protection Act, you will see that it has also got a mention which you will find in the judgment, wrongly dealt of course, that is the OMEX judgment, 58.1a Roman 4. Roman 4 talks about central authority. Now central authority, I don't think any matter has come to the court. What then happens in PMLA? PMLA talks about an adjudicating authority. And that adjudicating authority is an intrajudicial mechanism where an attachment order is passed, that order is looked upon by the authority, and he has got a statutory time limitation of 180 days to look into the aspect. He cannot go beyond 180 days. Then the order becomes non-est. And it is also, and in case if the quorum is not complete, then there are several cases where the orders have also been struck down that it is quorum non-judice. Now fourth thing that I am coming to is the new mediation aspect which has been added to the Consumer Protection Act. It was not there. there's a full chapter of mediation. Why has mediation become now important? We dealt with the court, tribunals we dealt with, tribunal came out, tribunal again got in, but still the ratio of the litigants and the judicial mechanism is not to the extent or not so satisfactory that a dispute can be adjudicated upon within the time frame which is either written by the statute, even if it is not written in the statute, then it cannot go endlessly. Therefore, the mediation in Supreme Court, the matters only go, as far as I am concerned, subject to correction, when if it is a matrimonial dispute. So is not the case in Delhi High Court. So is not the case in Delhi District Courts. They also look into commercial matters. In fact, when Justice Waziri was a judge of Delhi High Court, he got a lot of 138 cases. 138 cases, when they come to Supreme Court has got a simple, it acts like the way DRT acts. Are you depositing the amount? We'll hear your appeal thereafter. So it has got its own unwritten code of deposits. And it looks into the aspect that a person who was issued a check, wrong check, has fought for so many years, at least let him get some money. So that entire rigmarole of the evidence, the exhibit, the cross-examination is not only a wastage of a good number of years, but it is also a wastage of the whole procedure of you've got a paper, there's a bill of exchange, intention or no intention, liability or no liability, but a check has been issued. So I'm not saying that evidence is something which does not find out the truth, but when we try to find out too much truth, then we think we know it very well that too much truth brings out too many lies, and judicial lies are the best. So it finally, we in fact somebody said that the work of a trial court judge is very difficult. He has to find out the third lie from two set of lies, and that is what is the law. So within this whole very ornamental law, mediation is a very informal mechanism where the mediator appointed, many of you must be a mediator, I am not, is not even aware of what is the dispute. He doesn't even know whether the mother-in-law has beaten up the daughter-in-law, or is the husband who has thrown out the wife, or is the wife who threw out the husband. But it says there's a dispute, you settle it. If you are able to settle it, it's a successful mediation. If you are not able to settle it, it's a non-starter. So ultimately, after reading all this law, after all these law schools, after all this law college, if we have to, it's like sitting under a tree and deciding as a sarpanch decides in a village. So the best is that, go get yourself trained as a mediator, forget about this entire evidence and CPC and CRPC and Supreme Court rules, and become a mediator. So the jurisdiction of a mediator is undefined. And a jurisdiction of a mediator, it was, I think, maybe a decade and a half back, there was a service matter. It was a very hard matter. The person, the claimant had lost her husband. She was the wife. She wanted the pension money. She was literally on the roads. So I remember going to a central agency and I said that, why don't we decide over the table? I did not even use the word mediation. He said, no, it's a question of my service. So even if 1 rupee goes, then I'll have to answer it. Let it go to the court. And the matter, I think, is still pending. Matter is no more with me. But just remember the plight. The husband died, the wife must have died, the children. So this is the very long pendency. So the tribunal, if they were founded, and Article 323A, if it was brought into being, Article 323, if it was brought into being, and Article 323A deals with Article 309, that is the service matters. It is with the public civil services. So why can't, at least if we just pick up a single act and we pick up a single judgment passed by 7 judges, why can't we together sit down, think and deliberate that why is this act still what it was? So is tribunal useless, or is Article 227 unnecessarily it got the clause of inclusion, or is it Article 136? Because every day what a lawyer hears in Supreme Court is it's admission court. SLP is not a matter. It's not a matter of right. It's not an appeal definitely. So it says that no, there's no question of law. But where are you going to get a question of law from? If a person has retired, he has not been given his pension, and there is no disciplinary proceeding against him, it's just because of a departmental, what we call red tapeism. Then is there any remedy available? I have a statute, I can read it out to him. There are people who have worked ad hoc and casual for good 20 years, 25 years. They are on the verge of superannuation. Today they are regularized. What relief are they going to get? They have a big backlog of pending amount. So these are few subject matters where if we look into the subject matter for which the statutes have been created, is a parliament also in its own wisdom it is looking into it, judiciary is also doing its job, but at the end, in between both the system is the litigant. He is neither benefited here, he is neither benefited here. So finally he just says that okay, his anger is, I will vote him out. Or when he comes to the court, he'll say, I'll change the lawyer. Because he cannot change the judge, he cannot change the court. So therefore, I purposely deliberated and took this topic that jurisdiction of a tribunal is relevant, and it's relevant to the extent that you have a high court which is looking to you constantly. And it is also seeing that whether you are working within the bounds of the authority which is with you, or you are spilling beyond the bounds of the authority. Are you acting in a legal manner? Now, when we say that a judge should act fearless, he should be independent, he should deliver a judgment, under these circumstances, can a court or can a tribunal pass an order knowing that this order is going to go and be examined in what? In a writ of certiorari. So writ of certiorari, very interesting. Sheshu must be remembering it. In 1969, the first case that was filed, and ultimately it became a 9-judge judgment. That was an order passed by one of the courts. It is, what is the name of the matter? I'll tell you the name of the matter. It's 9-judge judgment. And it says that I am challenging this order by way of a writ of certiorari. It was a judicial order. So Supreme Court at the first, all the courts said, no, you just cannot. Wrong or right, you go and file an appeal. But you cannot challenge an order saying that it is unconstitutional. Because the moment, what are we doing under Article 227? When we file a service matter, when we file an order passed by the inferior court or the tribunal, we are challenging the judgment by way of a writ of certiorari saying that please quash it. In Supreme Court, we don't say the word quash, we say set it aside. The Supreme Court doesn't even do that. It simply says, I'm granting leave, I'll look into the subject. So the whole prayer that we make, or the conventions that we lawyers have been following for years together, I was trained into that, I'll train my juniors into that, my juniors will train their juniors into that, is the stereotype of the whole constitution, a complicated procedure. In fact, it becomes more complicated had it only been one CPC, one CRPC, which again is going to, I think from 2023, by 2023 end, we will not be knowing any statute because every law is going to change now. So therefore, what we say, we used to say it in economics, that you cannot have a state of flux. You have to have somewhere a convention or a written code. In India, we have a codified law. We had it from day one when the country became independent. We are not UK. We have the doctrine of stare decisis. We have the doctrine of ratio decidendi. We also have obiter, which guides the inferior courts. Obiter is not binding on Supreme Court itself, but it is binding on the inferior courts. Then with this, are we not just into complicated and roaming, round and round, with which is the forum, how I should go, what relief I should get. So it is a lot of computer, it is a lot of work, but it is very little result. So I think My time is also up.
No,
Thank
it's
you.
continue.
No, so this is, this is what is my insight into it. If anybody wants to ask me something, you're most welcome, because let me make it interactive, I can answer your questions.
Can you give this 1 second? Mic, can you give the mic? Can you help? Can you help her?
Yeah, it's just this. no?
Yeah. Not Thank you, Kumudji. So nicely, you have very clarity about all tribunals all over India. Very nicely explained. I mean, Chandra Kumar judgments until date as a latest judgment of this court. Thank you very much, and
My pleasure,
Yes,
equally.
yeah, a lot of clarity you have given to, I mean, family courts also and PMLA courts and other things. I mean, very nicely explained. It's a thought provoking. One has to look into seriously actually where we start, where we ends, and CPC and all of this. Thank you very much. So, I mean, for a new beginner also, one can understand, one can proceed.
Yeah, the whole idea is, as I told you, that it's a continuing legal education, and Sheshagiri Rao's contribution to carry on and to have this in the Supreme Court. Is we are all blessed. I mean, if I don't attend, it's not that I don't watch. I watch it on the YouTube. So I know, what are the subjects. Many a times they are very relevant subjects, and this must continue, and it's beneficial for everyone, for the speaker also, because otherwise, we just read a judgment in a very casual manner, 4 lines, what we have to argue, 1 paragraph. But if you are just asked to speak on a subject, you will have to go deep into it. You just cannot.
Yeah, then we'll take your autograph and as a message. This is